You might be confused about how DPDPA, the Puttaswamy judgment, and GDPR fit together for CLAT passages. By the end of this video, you will be completely clear about this topic. Have you wondered why India needs both a constitutional test and a statutory law for privacy? Or how international rules like GDPR change the answers examiners expect? We will focus on the basics for beginners and cover DPDPA rules, Puttaswamy's threefold test, GDPR differences and quick exam tips, and towards the end, we will understand a key idea that most UPSC aspirants miss. DPDPA applies to data processed in India and to services offered to people in India, and it requires explicit consent that is free, specific, informed, unconditional, and unambiguous. Sensitive personal data such as health, biometric, or financial information needs enhanced security, like encryption and restricted access. And data fiduciaries must give clear notices about purpose and third-party sharing. Individuals can access a summary of their data, request corrections or erasure, know the identities of third parties with whom their data is shared, and withdraw consent, which halts further processing unless a legal obligation applies. A statutory data protection board enforces compliance, investigates violations, and can impose penalties up to 250 crore rupees or restrict data processing for non-compliance. The Supreme Court in Puttaswamy 2017 recognized privacy as a fundamental right under Articles 14, 19, and 21 and set a threefold test of legality, necessity, and proportionality for any state intrusion. Puttaswamy gives the constitutional backbone, while DPDPA supplies the statutory tools. So actions must satisfy the constitutional test and the DPDPA safeguards like explicit consent and data minimization. GDPR is an EU regulation with extraterritorial reach that emphasizes lawfulness, purpose limitation, data minimization, accountability, and strong rights such as erasure, with fines up to 20 million euro or 4% of global turnover. Key CLAT differences to remember are that GDPR requires breach reporting within 72 hours and uses a higher global fine model, while DPDPA differs on timelines, scope, and some lawful processing grounds. These are common comparison questions. Think of privacy rules as three locks. Puttaswamy is the constitutional lock, DPDPA the national statutory lock, and GDPR the international lock. And lawful processing must fit the right keys. This concept is very important for your exams because CLAT often tests the link between constitutional principles and statutory data protection rules. Questions from this topic are frequently asked as fact battles in the law paper, as objective items testing exact terms like explicit consent, or as comparison prompts between Indian and international regimes. Quick recap: explicit consent and transparent notice, special protection for sensitive data, Puttaswamy's legality, necessity and proportionality test, GDPR's data minimization and 72-hour breach rule, and penalties to remember: 250 crore rupees and 20 million euros or 4%. You're now ready to tackle CLAT-style questions on data privacy. Keep practicing these frameworks and continue with EduRev for short notes, passage practice, and quizzes. Keep going. Your clarity on these frameworks will make your answers precise, concise, and persuasive.